In this section, we're going to continue our study of negotiable instruments, and we're going to cover holders in due course, defenses, and liabilities. So a holder in due course is a holder of a negotiable instrument who takes an instrument for fair value, in good faith, and without notice that anything is wrong with it. And the reason we care about this is because a holder in due course of a negotiable instrument can receive more rights than the party or parties who held the instrument before them. Because of this, negotiable instruments are used quite often and they're passed from one party to another. And so often we'll have lawsuits and the court will try to determine whether someone is a holder in due course. So they would have to meet all of these things. They would have had to take the instrument in good faith, which means they took the instrument with honesty in fact and conforming to the accepted commercial practice of fairness. So they took the instrument in good faith. They had clean hands. They didn't know anything was wrong with the instrument. Okay, there's also what we call the shelter provision, which says that a holder who receives an instrument from a holder in due course acquires the rights of the holder in due course, even though he or she is not technically a holder in due course. This is designed to permit holders in due course to transfer all the rights they have in the commercial paper to others. So this is designed to help business flow freely. A holder in due course is not subject to personal defenses. Personal defenses are defenses that can be used against a holder but not a holder in due course of a negotiable instrument. They're called limited defenses. Breach of contract is the party to whom the instrument was issued breaches the contract by failing to perform or by performing in an unsatisfactory manner. The reason that we don't require holders in due course to be subject to personal defenses is that we don't want to require someone to be liable to a person who they have not ever dealt with. So remember, we can negotiate negotiable instruments. We can negotiate them. We can transfer them by endorsement. So I might be the third person to whom that instrument has been endorsed. I am a holder in due course. I have never met the maker of this instrument. So it wouldn't make sense. It wouldn't be equitable for me to be subject to defenses based on the maker's conduct. Some personal defenses that we're going to talk about here are lack of consideration. So it's a defense used when there was no consideration in the underlying contract. Failure of consideration. So it's a defense that the maker or drawer may use when the other party breaches the contract by not furnishing the agreed consideration. And fraud in the inducement, when someone is induced by a fraudulent statement to enter into a contract. So this doesn't change liability of the maker of the instrument, but it doesn't subject later holders who are holders in due course to that liability. And this is a little bit different rule for holders of consumer credit contracts. They are subject to all claims and defenses that the buyer could use against the seller, including personal defenses. All right, so here are the most common personal defenses, and remember, these are the ones that we cannot use against a holder in due course. A breach of contract, failure of consideration, lack of consideration, fraud in the inducement, lack of delivery of a negotiable instrument, payment of a negotiable instrument, so when the drawer or maker has paid the amount of the instrument, infancy and mental incompetence, illegality, duress, fraud as to the essential nature of the transaction, bankruptcy, an unauthorized signature, and a material alteration of the instrument. So we can contrast this with real defenses, and real defenses can be used against anyone, including holders in due course. These are universal defenses. So even though this holder of this instrument knew nothing about the problem with the instrument, they still can be liable for these real defenses. Infancy and mental incompetence. The maker or drawer of the instrument was a minor or mentally incompetent. Illegality. The underlying contract for which the instrument was issued was illegal. Duress. The instrument was drawn against the will of the maker or drawer because threats of force or bodily harm. And bankruptcy. An order for relief was issued by the federal courts that ended all the debtor's outstanding contractual obligations. Also, unauthorized signature. Someone wrongfully signed another's name on an instrument without the authority to do so. And material alteration, when the amount of the instrument or the payee's name was changed wrongfully after it was originally drawn by the maker or drawer. No person is going to be liable on an instrument unless that person's signature or the signature of an authorized agent appears on the instrument. So liable, of course, means have to pay on the instrument. And the following people are obligated to pay an instrument without reservations of any kind. The maker, remember the person who creates the note, the issuer of a cashier's check or other draft in which the drawer and the drawee are the same person, this is usually the bank, and the acceptor of a draft. Endorsers are obligated to pay an instrument only when the following conditions are met. Remember, the endorser is the one who signs the instrument. So, 1, the instrument must be properly presented to the drawee or party obliged to pay the instrument, and payment must be demanded. 2, the instrument must be dishonored. And 3, notice of the dishonor must be given to the secondary party. Presentment is when a demand is made by a holder to pay or accept an instrument. So I present this negotiable instrument to the bank, and then they don't pay it. They dishonor it. That means they refuse to pay a negotiable instrument when it's due or refuse to accept it when asked to do so. And again, for the endorser to be liable on it, it must be presented and it must be dishonored.